Welcome to today's program titled From DEI to Merit-Based Mandates, Legal Insights and Strategies on the Recent Executive Orders. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to this form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you so much, and welcome to everyone who is joining us today. We recognize there's a lot of interest on the issues given the impact to employers and contractors generally. Just to kick things off, my name is Annette Timon. I'm a partner here at the law firm of Seyfarth Shaw. I am thrilled to be joined by my colleagues, Camille Olson, who's also a partner here in Chicago, as well as Rachel C., who's senior counsel and is in our out of our DC office. We together bring some, I think, unique perspectives from a counseling perspective to litigation, as well as to government and agency perspective as well, given our backgrounds and our experiences. So we together are collectively sharing that insight with you. And I would say as we kick off, we are certainly gathering at a pivotal moment. The legal and regulatory landscape around diversity, equity, and inclusion is shifting. Organizations are faced with navigating new expectations, challenges, but also opportunities. And so regardless of your role within your own organizations, understanding the changes that are coming, that have just been announced, and that we are expecting is really critical. And it's not just for purposes of maintaining compliance, but also to shape strategies that align with both the legal mandates and your organization's long-term goals. And our goal as part of this discussion is to kick off the thinking, the understanding around these strategies moving forward. And we have a lot to get through, so we'll go to our next slide just to give you a high-level focus on the agenda. We're going to focus today on the evolving landscape as I shared. We're going to start with an overview of the key executive orders that have been implemented that impact diversity, equity, and inclusion. Some of it is background information for you and context to understand the shifting landscape. We're going to then pivot and spend most of our time talking about the most recent executive order that impacts federal contractors and private employers. Potentially, we're going to talk about some compliant and targeted DEI practices, and then finish up with strategic responses and next steps. So with that, we'll go ahead and get things started, and Rachel is going to kick us off with the 4 key executive orders that were recently submitted.
Good afternoon, or good morning if you're in that time zone. I'm happy to talk about our perspective on what is going on with all of these executive orders and to give a high-level view of how it relates to DEI. I think one of the most important concepts to understand here is that this is such a rapidly developing area, intentionally so, that part of the strategy, part of the messaging that's going on across all of the administration's action is they are literally flooding the zone with executive orders, and that is conferring multiple advantages on them as the news cycle keeps on moving. Next slide, please. So on day one of his new administration, President Trump, as one of his first batch of executive orders, he signed a foundational executive order just revoking a bunch of executive orders that President Biden had signed. And one of the stated purposes of revoking these orders is President Trump saying that the Biden injected DEI into our institutions and, quote, corrupted them by replacing hard work, merit, and equality with a divisive and dangerous preferential hierarchy. That rhetoric that we see in President Trump's executive orders and his speeches, his inaugural address, and all of these other documents and campaign promises, I think that's important to contextualize what we're seeing on DEI. And very importantly, when we think about as DEI practitioners, what DEI practice policies and practices are, there's that view of the world, but there's also the rhetoric that we're seeing about quote unquote DEI culture that goes far beyond that. On the Biden administration orders that were revoked, there's many of them, many touching on DEI issues and saying that the federal government's policy is to prioritize DEI and equity. Next slide, please. So the other day one order that specifically mentions DEI talks about federal agency programs. And I think that some of the confusion with folks in the private sector or the contracting world are that, looking at how does what the government is saying about its own DEI and DEIA programs, how does that impact what is going on outside of the government? And so this first step on day one was to order the termination of all internal federal government DEI programs. That's the offices and positions, and that includes environmental justice and equity action plans. And so as part of that, they're asking the agencies to identify who's doing this work. And there's ongoing meetings with the White House saying, how are you doing with shutting down the internal federal agency processes and offices? After this executive order, there was direction from OPM, the Office of Personnel Management, directing that federal diversity personnel be furloughed, placed on administrative leave, and also actions, encouragement, threats to the federal workforce to identify programs that have been renamed to hide it, to conceal it from the reach of these anticipated actions. Those are federal programs. So in terms of looking at private sector programs that have been renamed, this executive order doesn't apply. It's looking at the federal programs. Next slide, please. The other DEI related executive order that was signed on day one was named Gender Ideology Extremism. It's an anti-transgender executive order, and it directs federal agencies to adopt a binary biological classification of sex, saying that it is an immutable, unchangeable characteristic. It directs the agencies, it directs the federal government to say that sex segregated spaces should be based on biological sex, based on immutable biological sex. And so it's going to lead to federal restrictions on sex segregated spaces. It also impacts identification documents at the federal level, passport, Social Security, and those processes have rapidly undergone changes at the administrative level. Again, the way these executive orders all work is that they direct the agencies to take action. They are not self-executing, but some of the agencies are executing extremely quickly, as we'll see in the context of some of the other executive orders that we're going to dig into here. Next slide, please. So the meat of our presentation is about the January 21st executive order called Ending Illegal Discrimination and Restoring Merit-Based Opportunity. First, I want to talk about some of the other things that this executive order does that may have been lost in some of the oh my gosh, what's going on here? So the first day one executive order of President Trump revoked many of President Biden's executive orders. The January 21st order of President Trump revoked some older EOs touching on DEI issues. It's also directing the federal government to review, the Office of Management and Budget, to review government-wide programs and, again, eliminate references to DEI and DEIA principles from contracting, acquisition, all of the programs. And again, it's saying not only terminate the internal federal government DEI offices, but also sets in motion the termination of DEI programming. And one of the keys here is that it doesn't have to be named DEI programming to be within the reach of this order for termination. It's looking at things like advancing equity or equitable deployment of financial government assistance and resources. So the potential reach of this directive is extremely large because there's now a direction to scrutinize all of these federal programs on equity that may be interpreted as advancing equity. It will be a robust discussion, I expect. Now, the meat of what we have in the January 21st executive order is the revocation of EO 11246, which ends affirmative action obligations for federal contractors. But beyond the federal contractor specific portions of this executive order, it's also directing all federal agencies, not just OFCCP, not just DOJ, all federal agencies to take action against DEI discrimination throughout the private industry. And so the rest of our discussion today is going to focus on those provisions. Annette? Annette, you may be muted.
Thank you. Sorry about that. We'll go ahead and get into the next section of the presentation on Executive Order 11246 in particular and the revocation period. And on the next slide, you'll see the four main section, at least how we're conceptually thinking about the main provisions of what we're for purposes of this discussion, the illegal discrimination executive order, because there were a lot of executive orders that have been issued. So Rachel just walked us through the requirements that are set forth in sections 3A and 3C. We'll go ahead and leave those there, and I'm not going to touch on those because she already dealt with that. And Camille shortly is going to talk about what's in section 4, which relates to private sector. I'm going to spend some time now talking specifically about federal contractors and federal subcontractors and the impact of eliminating Executive Order 11246, the specific actions that OFCCP has been prohibited from engaging in, this certification requirement. Rachel's going to touch on that, as well as False Claims Act. So on the next slide, we'll get into the specifics here. So the impact on 11246 is, it's a pretty big shift. It's a executive order that has essentially been in place for nearly 60 years. And so it really is impacting the framework in many respects of federal contractors and how they approach hiring, promotions, terminations, and general employment practices. It is very important to make clear that as part of the purpose statement in these executive orders, there were two. One is, the statement was that, federal civil rights protections support equality of opportunity for all. And second, that illegal DEI and DEIA programs or policies violate those civil rights laws. And we are putting the emphasis on the term illegal because we believe that that leaves the opening that not all DEI and DEIA programs and initiatives are illegal. And so that becomes a big question about what is covered, what isn't, and we'll spend a little bit more time trying to unpack that. It certainly impacts contractors. In particular, they have 60 days to have a sort of transition period. It's going to end on April 21st. Actually, it's 90 days, I believe. Sorry about that. 90 days that ends on April 21st. So it gives a limited window of time to sort of look at programs, make changes to your affirmative action obligations that you traditionally had in place. And on the next slide, we'll talk a little bit more about the OFCCP's transformed role. So the OFCCP has been specifically prohibited from engaging or promoting diversity, from holding federal contractors responsible for taking affirmative action. And in our world, we have known that to be not taking action on the basis of race or gender, but instead to affirmatively review that you are in compliance with equal employment opportunities, and to the extent you had barriers in your workforce, you were addressing those barriers. And that's how we have long viewed affirmative action in the federal contracting space. That's part of the language that has really caused a lot of confusion, I would say. But that is in the federal contractor world. If you're doing this work, you understand that. And then the third piece is, I think it's the most specific and direct maybe practice that's been prohibited, and that's allowing or encouraging workforce demographic balancing based on a host of protected activities, protected categories, including race, color, sex, sexual preference, religion, and national origin. And most federal contractors would understand that to generally mean the goals that they worked towards. Now that the executive order doesn't specifically call out goals or aspirational goals or anything like that. It refers to it as workforce demographic balancing. So there's room for, thinking through what that exactly means. And then on Friday, January 24th, as we were trying to understand exactly what the agency's position was going to be with regard to open audits, with regard to open requests for information, conciliation agreements, and the like, there was the Secretary of Labor issued an order to cease and desist all investigative and enforcement activity. And as a result, OFCCP was directed not to engage in any sort of follow-up questions with regard to requests for information, issue scheduling letters or anything of that sort. And also, with regard to Section 503 and VEBRA, which remain in place for federal contractors, those are statutory provisions that deal with individuals with disability and protected veterans, including outreach and goals with regard to those particular groups. Those are statutory, and so the executive order did nothing to address those. That being said, the OFCCP currently has investigative authority over those. For now, those provisions are held in abeyance. We are expecting additional information and guidance around Section 503 and VEBRA. So it certainly leaves, some open questions around how those programs are going to be implemented. There's, again, as I mentioned, statutory requirements, regulatory requirements in place, but in terms of oversight by OFCCP on those two issues for right now, there's a hold on those. So if we go to the next slide, I wanted to quickly just address what should federal contractors specifically be thinking about when it comes to your current existing obligations. You've got 90 days, you've got some time here to do a bit more with regard to how, what needs to be done, because for 60 years, you've had policy statements and certain language that you have in multiple places. So it's really important to make sure you are addressing that. So some high level thinking for you all to take back to your teams is making sure that you are removing references to Executive Order 11246 from existing policy documents and forms. You're updating your posters. We're waiting for, it's going to take some time, obviously, for the EEOC to issue their updated Know Your Rights poster, but there's references all over it that reference Executive Order 11246. So we are expecting updates there. There's a pay transparency, non-discrimination policy document that's only required for federal contractors. Evaluating revisions to your EEO tagline, looking at your subcontractor flow down language and how you're messaging that information. There still are some requirements that survive because of Section 503 and VEVRA, but removing certain language with regard to the executive order is important. Evaluating any references in your policy documents or materials that currently refer to affirmative action, evaluating the implications. Many contractors are also state contractors. And for some states, they have their own requirements, but oftentimes they just refer to the executive order. So you've got to understand and unpack that, making sure your procurement teams understand these issues as well. And certainly talking with legal counsel about any future analytics, how you're going to handle the changes that really are targeted to executive order 11246 and the implications there. So Rachel, we've got some other new certification requirements that are critical, so why don't you walk us through those?
Absolutely. So one of the things in the order is that now all new federal contracts and grants will need to contain a certification that either the contractor or the grant recipient is complying with all applicable federal anti-discrimination laws. And that it's particularly saying that it's not, the certification has to say that you're not operating any programs promoting DEI that violate these applicable laws. And what I think this demands attention to is that if this term is added to your contract or the government seeks a modification or imposes this on renewal, what is going to be the basis for your certification that you're complying with the law like this? And so, as we'll discuss later on in our presentation here, we think it's really imperative for folks subject to this certification to consider how are you identifying what programs might be within the reach of this certification, not just that are specifically named DEI programs, but are within the broader rhetoric that's floating around here, and how you're evaluating these programs and what legal advice you might have received related to compliance. Where I think if you're just skimming the executive order, what might not be evident here is there's this provision about that it must be material for purposes of Section 3729B4 of Title 31 U.S. Code. What does that mean? Next slide, please. So what is being set up here with that materiality provision, that declaration, that compliance with these non-discrimination provisions and DEI programs? It's a recitation that it's material for purposes of the False Claims Act. The False Claims Act allows, of course, the government can go after contractors and grant recipients for making false claims for fraud, waste, and abuse. That's something that government enforcement has always done. What the FCA has always allowed is since it's the start, it allows private whistleblowers to bring lawsuits on behalf of the government and receive a percentage of that recovery. It is a bounty bill. And thus, what the executive order is intentionally doing is it's making it easier for a claimant to prove up a False Claims Act qui tam lawsuit, saying that there's a declaration in the certification that compliance is material to every contract. The other thing I want to emphasize here that may have slipped by here is, I think we focus on federal contractors when talking about what's going on with affirmative action in 11246. What this executive order is doing on this certification requirement is expanding the reach on these DEI issues to include federal grant recipients, all federal grant recipients across all the various domains of people who receive federal funding. These new grants, according to this executive order, are going to be subject to this certification. This is a broad-reaching requirement. It goes far beyond federal contractors. Next slide. I think, Camille, this one is yours.
Thanks so much, Rachel, and thank you, Annette. Looking at the next slide, when I think about the next slide, which is up here and is described as really what are the implications for the private sector. I've listened to the webcast so far, of course, along with you, and the requirements that have been discussed by both Annette and Rachel, definitely directly impact federal employees, definitely directly impact federal contractors and subcontractors, as well as federal grantees, as was just mentioned. This is a little different. When you get to section 4, which is the last section of this particular executive order, beyond what you might take directionally, if you're not a federal contractor or a federal grantee, what you might take directionally in terms of what are the appropriate ways to think about your policies and practices to both be inclusive, to both, be sure that you're getting, the most qualified employees, but also staying within the contours of applicable law. You're looking at those directionally, right? This is what the administration is saying with respect to its direct impact on federal employees, contractors, subcontractors, and grantees. Section 4 is different. Section 4 really looks to all private employers. And what it says is the government is directing all federal agencies. And if you think about federal agencies, we're not talking about, all federal agencies that deal with EEO or workplace issues. We're talking about all federal agencies, over 400 of them. So the heads of all of those agencies are to take immediate action to advance the policies of individual initiative, excellence, and hard work in the private sector, not within the federal workforces solely, but in the private sector. So that's the first requirement here of the federal agencies. The second is that the Attorney General, and the Attorney General has been nominated, Pam Bondi, but has not been confirmed yet, along with each of these agency heads, as well as the director of OMB, who has also been named but not confirmed, to provide recommendations for enforcing the EEO laws and to take all other actions that are necessary to encourage the private sector to end illegal discrimination and preferences, including, it says, DEI. It doesn't have the word illegal DEI there, but there's no question illegal is a qualifier and should be a qualifier as you think about all your DEI practices. So in addition to focusing on the issues of improving and encouraging individual initiation and hard work, it's also what can be done to ensure compliance in the private sector is happening with respect to compliance with EEO laws, and also ending any illegal practices that are not consistent with those laws. So that's every agency. When you think about every agency, I just think about, you're talking about the Department of Defense, the Department of Energy, the Department of Homeland Security, the Department of Agriculture, agencies that you would not think of being in this space. So to me, this is one of the broadest pronouncements that we see directly impacting all employers in the United States. In addition, there's a specific statement in this section that within 120 days, the Attorney General must create a strategic enforcement plan identifying sectors of concern. Those sectors may be industrial sectors, it may be geographic, it may be by topic in terms of particular practices or policies, we don't know for sure. And also identifying the most egregious, is the language, DEI practitioners within each of those sectors of concern. It also asks or requires the Attorney General's plan to include specific steps that should be taken to end or dissuade private employers from using any programs that are discriminatory, that are illegal. And this is one of the most, I think, unusual and aggressive provisions here. It also asks that plan include from every single federal agency an identification of up to 9 potential investigation targets, focusing on large employers, and you can see the list here on the slide. But that is clearly going to be a question that many people are going to be wondering, how are those different agencies going to be able to identify those, especially if the issues of workplace policies were not within their purview. So this is something that's important. It's something that, because of the timetable we see here too, I think we all have an emphasis and an urgency for review of our policies and practices. And I think this is one example of one of the reasons why that urgency is well placed. Let's go to the next slide. I've been talking about the private sector, and as we go into this next section, we're going to talk a little bit about what we see as what the EEOC is going to be doing in this space and what it has said with respect to various DEI practices through various commissioner statements, as well as what we already have seen by individuals that are key to this administration's policies in terms of statements and actions that they've taken recently. I'm going to start it out with discussing some of the EEOC commissioners' positions and statements on this, and then I'm going to turn it over to my colleague Annette to talk a little bit about some of the targeted or at-issue DEI practices that have been raised over the last couple of years. So let's go to the next slide. So given we had these executive orders that just came out last week, you know, what also did we have that was new last week in the area of EEO? President Trump named Commissioner Andrea Lucas as acting chair of the EEOC. So as an EEOC commissioner, I would say that she had previously spoken quite a bit about her perspective on employer DEI programs. She did not attack all employer DEI programs, and I think that's an important statement. But she has stated that when she looks at the spectrum of DEI related initiatives, whether they're employer training programs or mentoring programs, sponsorship programs, diverse candidate slate programs, that those are activities, even before Muldrow, the Supreme Court case, that are covered within the purview of the federal laws and can be analyzed and considered under them. So what happened immediately upon the issuance of these executive orders? Just before the issuance of them, we saw now acting chair Lucas state on X or Twitter that her view that far too often diversity goals lead to discrimination, and that she's talked about this in many different places and forums throughout her time as commissioner. That is true, and that diversity motivated discrimination is still unlawful discrimination. And she closed this particular tweet with the statement that it's long past time for employers to ditch DEI and return to EEO and merit. And if you think about some of the language in those 4 executive orders that Rachel and Annette just took us through, that language focusing or leaning into EEO and merit is what we have seen in much of the language in those particular orders. Once the executive order came out that we're talking about now, Acting Chair Lucas came out with the statement that's here on the slide, which says, consistent with those orders, her priorities will be to root out unlawful DEI motivated race and sex discrimination in employers' policies and programs. At the same time, literally, if we go to the next slide, just hours later, we saw the 3 Democratic commissioners also issue a joint statement on X or Twitter. And that statement is an interesting statement. And in the first paragraph of it, and there were actually, it goes on, but I'm just giving you a couple of the paragraphs here. In the first paragraph of it, it talks about the fact that it is important to obviously not just be consistent with the EEO law's requirements, but that doing so does require not just inaction, but proactive action by employers to ensure that barriers are reduced. And then you see in the second paragraph here, these 3 Democratic commissioners also describe certain common practices, such as monitoring hiring and promotion decisions, skills-based hiring, standardized in interview practices, robust recruitment, have been and will continue to be lawful, important ways to promote the goals of equal employment opportunity for all. So I leave these here. I think that what a lot of people are grappling with is the question of what is going to be consistent with our EEO laws going forward. And as you know, we have all learned and are all learning, a label on a practice, a label on a policy is probably not going to give you the answer as to what you're looking at. That you really have to look into the details of the generation of that particular policy or practice, the actual language of it, and then how it's implemented and what the results are of it. I'd like to go to the next slide. In addition to the statements that I just discussed, Acting Chair Lucas, over the course of the last 12 months, has spoken to employer groups quite often. She has consistently described the types of practices and policies that she sees as furthering EEO and well within the grounds of being lawful. And she has consistently named a number of them. I put 5 of them here on this slide. You can see that she focuses on reviews of job descriptions, on reviews of interview schedules, on the structuring of hiring decisions and promotion decisions. In number 4 here, she also focuses on the process with respect to promotion and internal hiring in terms of the openness of that process, so that the opportunities are open to all that would be qualified or appropriate for any particular openings. And that with respect to various programs such as mentor and fellowship programs, that those are open for all. One issue that we've talked about is this issue of having good practices that really do assist employees, that advance opportunities, and finding ways to expand them and enhance them to ensure that they are able to provide those types of benefits to a wide variety of employees within your workplace. Let's go to the next slide, and I'm just going to mention there are 5 more that she oftentimes has commented on. Some have to do with training, and you can see that there are a number there. Individualized training that's based on a particular employee's particular skills, performance, and qualifications. as well as leadership development training that's offered to everyone. One thing that you may have not heard that hasn't been as publicly discussed is something that Acting Chair Lucas describes as thinking about different ways to remove obstacles to employees without focusing on anybody's protected status, but on what those obstacles are. And one example that she gives is thinking about the fact that somebody who is a first generation employee in a particular field or profession may have not had the benefit of mentorship or other networking opportunities that others may have when they aren't first generation in a particular field. And thinking about that, which could cross, for example, different protected statuses, but focus on the obstacle that could be addressed through specific mentorship or fellowship programs. And then, of course, we do see a lot of work being focused on privileged audits to identify areas with existing discrimination and also taking action to root out any issues that are found there. And then, number 10 is one that I think is a very, very important practice, which is obviously widening the pool of job applicants through sourcing and expanded sourcing opportunities through many different means, including job advertisements. With that, I'm going to turn it to the next slide. And I'm going to ask Annette to help us understand the flip side of that coin, which is what has been identified by some folks as potential at-risk practices.
This is great. Thank you so much. And, this is a question that we just continue to receive, right? We have heard a lot about the term illegal DEI practices, but that really hasn't been defined. So what we can share is that just some considerations here. America First Legal is an organization that was established in, I believe, 2021. And it was founded by Stephen Miller, who was a key architect of some of the policies that we're seeing come out now. And the organization actively challenged several, DEI initiatives that we're going to be talking about today. They have submitted, America First Legal submitted EEOC complaint letters inviting the EEOC to investigate various companies, and we have poured through those complaint letters to sort of understand what was catching the attention of this organization. In particular, we are focused on this one because Stephen Miller is now President Trump's Deputy Chief of Staff for Policy, which is a very senior level position within the administration. We are using it to provide insights, but as we walk through some of the specific initiatives, we are not taking the position that being, tagged or categorized in this category means that there is in fact unlawful discrimination. We're sharing this information just as a framework of what has caught the attention of individuals that are likely going to be driving some of these administrative efforts going forward. So let's go ahead and go to the next slide and talk about some of those programs. What we've done is we've identified 6 specific programs that have been identified in various EEOC complaint letters that were submitted by America First Legal to the EEOC, as well as some of them to OFCCP for federal contractors. Aspirational goals, I think, is one that you've heard talked about earlier today, both from the comments that Camille shared from Acting Chair Lucas, as well as the executive order itself that for federal contractors at least leans to this, workforce balancing, right? So that is an area that we do view as one that is certainly capturing the attention. And we've put some quotes here so that you can see what some of the language was that was directly cited by these organizations And it came right from the company's own website. So, for example, increasing representation of Black and Latinx associates, or increasing racial diversity in leadership teams. We're targeting X percentage of leadership roles to be filled by people of color, and also achieving gender parity. That's the kind of language that is coming out of, or we can tease out from the EEOC complaint letters that were filed. Similarly, diverse slates is another practice that I think has captured the attention of those that are very concerned about, employer practices. So comments such as, we strive to present a diverse slate of candidates, or we have a goal of diverse candidate slates for leadership positions. There was also reference on manipulating both interview panels as well as candidate slates to promote diversity. So again, that's another example. Supplier diversity, you may have, if you're tracking this work, you know that Section 1981 claims have been out there and certainly are on the rise. This is another area where focusing on representation of certain diverse suppliers, or increasing spending for minority-owned businesses, or prioritizing diverse suppliers, are also areas where looking at the issues is really important, because that's what's capturing the attention of many of the proponents of eliminating these practices. On the next slide, we'll see the next three. Development programs, and that can take many, many different shapes and forms. Some of them are development, formal mentorship programs, or leadership development programs for certain groups. Training for diverse talent, acceleration programs. Again, anytime it's focused in any way on a particular race or gender, that's being flagged as problematic. Internships and fellowships is another group. Oftentimes these were directed at students coming out of college, or recent grads, postgraduates. All of that is part of some of the examples that we were seeing and being challenged. And then finally, employee resource groups. That was also one that came up several times, and a company might list all the various programs and employee resource groups and initiatives that they might have, and the observation was that they were focused only on women, minorities, LGBTQ communities, but was not inclusive of all. So we just identified these 6 in particular as we reviewed some of the examples that we could tease out from these complaints. Those seem to be the most prevalent. That's not to say that these are the only ones. There are certainly others, and again, I want to reiterate that we are not at all suggesting or taking the position that these are unlawful in and of themselves. With regard to each and every program that you consider or think about within your organization, it's both evaluating the program itself, and I wish we could, have a program that says these are all okay and these are all not okay, and here's what's in the middle. It's very, very difficult to do, because it really depends on how each program is implemented. And every company has their own way of rolling out particular programs in their own organization. So with that, I'm going to turn it over back to Camille, who's going to talk a little bit more about kind of next steps and responses.
Thanks so much, Annette. There is a lot of work to do. I mean, if somebody said, where are we focused today? The focus, as I mentioned earlier, needs to be immediate. It needs to be inclusive of all levels of leadership in your organization. It needs to be inclusive of all departments. This isn't a human resource issue. This isn't a compliance only issue. This isn't a DEI only issue. This is an issue that really spans the entire organization. And if we look at the next slide, we've just put up here a couple of bullets here that I think that can help frame how you go to think about addressing the issues that are within our discussion today. First of all, I think you've got to include executive leadership. And yes, that means the executive leadership teams. It may also, and in our experience, is also meaning boards of directors in terms of understanding what your response is going to be, or what your ongoing culture and practices and policies are going to be, and what your strategic initiatives in this area are going to be. If you think about the issues we're talking about in a lot of ways compliance risk, right? Legal risks. But there are many different risks to an organization in connection with the various issues that we're talking about, that relate to its culture, that relate to its workforce, that relates to its reputation generally in the marketplace, that relates to employee engagement, in addition to various types of lawsuits, both from employees, from non-employees, from various groups, and from shareholders. So I believe that initially it is critical to get alignment in terms of the strategic initiatives and direction of the organization in light of what we've seen come out in these various orders. I don't think it's an issue of just cutting programs or just changing programs. It may be an issue of increasing resources, of expanding programs, of, in some areas, moving resources, or revising the nature of a particular program to enhance its availability to more employees. One question that needs to be considered, I believe, is what is your decision-making executive tree going to look like in terms of these decisions? Who is within that scope, and how are you going to make those decisions? I think it is critical. This is not an issue of one policy or one practice, that it's going to be critical, and it's not going to be that easy. But just like the federal government is being asked to make an identification of many different practices and programs of employers, within your own company, you need to identify any policy, any practice that you believe touches on any of these issues, so that you can ensure that they are aligned both with the law as well as with your own company's strategic initiatives and direction. And when I say that, it's not a generally we're doing good. Each and every practice and policy has going to be identified individually. And I mentioned this earlier, but what is the intent of the policy or the particular benchmark? There's a benchmark that's in it. How is that derived? What does the actual language of it say? And how is it working? What is the impact of it in your workforce to date if it's an existing policy? How is it working in place? Should there be enhancements? Should there be changes? Should there be new programs? And resources are obviously going to need to be identified to assist in this process. Rachel earlier talked about the issues with respect to the amendment to the executive order that eliminated 11246 and the certifications. I think it's going to be critical for you to think about what type of record do you want in place, including potentially legal review of your existing practices for those certifications. And finally, I just mentioned here, consider your different communication strategies for all stakeholders. And there are many different ones. I've included some here on the screen. And I'm sure there are more that aren't here that also will be necessary to consider. And that's not because you have different messages or different strategies. They have to be consistent, but they may need to be aligned a little bit differently in terms of the relevant issues for the different stakeholders and in terms of what it is you decide to communicate. With that, I'm going to turn it back over to Annette.
Okay. As we, we've shared a lot of information. As we go to the next slide, we wanted to, we're going to, if we have the opportunity, we'll answer some questions. There have been a lot of them pouring in. I will say that this is really a pivotal time, as I started the discussion, to really it's so incumbent on employers to really think through their strategy, think through their core values. It's so important right now more than ever, and as the landscape continues to evolve, we view this as a unique opportunity for employers to reaffirm their commitment to inclusion, to equal opportunity, and to belonging for all. The recent executive orders, it challenges us. It challenges all of us to rethink how we go to market, how we deal with talent. It encourages us to innovate, to adapt, to ensure our programs and our strategies are aligned with both the legal requirements and the core values that drive the business, and that also meet the needs of your talent, which is so critical to carrying out your workforce missions. This period really does involve a change and presents this opportunity to focus on the intrinsic benefits of the skills and experience that our talent brings to the workforce. And we believe that research does show that diverse teams do foster creativity and enhance problem solving and improve decision making. And it's up to us to harness all of those benefits to create inclusion in our corporate culture, not just as a compliance measure, but as a strategic objective as we move forward to ensure that we can obtain the top talent within our organizations, we broaden our market appeal, and we strengthen our competitive advantage. Now is the time to engage in those thoughtful discussions that Camille was really talking about, thinking about all of your stakeholders. We've had many, many discussions with C-suite, board level discussions that also includes employees, your customers, your investors, because there are a lot of stakeholders and a lot of inputs that you want to take into account as you move forward. But making sure that there are clear communications and demonstrating the dedication and commitment to fostering inclusive environment, we believe will not only enhance your brand reputation, but also build trust and long-term business resilience. The regulatory frameworks are going to shift. I mean, there are so many questions that have come up just on this panel today. We've tried to address so many of them, but it's certainly shifting, and we will have more and more insights as in the days and weeks to come. But from our perspective, those companies that really rise to the challenge and proactively adapt and reaffirm their dedication to their core principles are the ones that are going to thrive moving forward. We certainly recognize these are challenging times, and questions are going to continue to come down. This is really, when you think about it, today's Tuesday. It's been less than a week, really, since the order came out. It was a Tuesday night last week that we were sort of unpacking and sort of realizing, and the information wasn't even available until the wee hours of the morning publicly. So there is a lot to unpack and understand, and we fully understand that. I will say that our teams have been advising employers on these issues for years. So we are well suited to help you navigate these really challenging times. On the next slide, there's just a couple of resources. If you haven't seen them, the legal updates that we issued on the executive orders are available for you. The slides will be shared with you, as well as the information. A recording will be shared with you. And then on the next slide, for those tracking CLE, we'll want you to scan this particular I don't know what the name of it is, but just scan the QR code, there we go. You will need to input the verification code, so make sure you grab that. It is SS, as in Seyfarth Shaw, 2425. That number again is Seyfarth Shaw, 2425. I know that Rachel was sending responses as quickly as she could while we were talking here. That's why we front-loaded her so that she could quickly answer as many questions as we could. We fully appreciate what a difficult time this is, and there's a lot to understand, to process, and to think through within your own organization. We stand ready to help you along the way, and we will continue to update you as changes coming forward. So thank you so much for your attendance. We will continue the dialogue. Thank you so much.